So obviously the topic was defending unpopular clients, but I'd like to say that in this room, the lawyers who've done that work are very, very popular. And that is certainly true of our next speaker, who is a dear friend of the organization, somebody that I think we all deeply revere, admire, and are very honored to have present at any ACS event, and again, is an extraordinarily popular person here in this room as he does his work defending unpopular clients. Stephen Bright is president and senior counsel of the Southern Center for Human Rights and also teaches at Yale Law School. And I don't know how people do those things like that, but he's able to do both incredibly well. He was a director at the Southern Center from 1982 to 2005 and has been in his present position since the start of 2006. He's been representing unpopular clients for 40 years and often in death penalty cases. Just last month, the Supreme Court granted the Southern Center's petition for certiorari in one of those cases, Foster versus Humphrey, to review a challenge to racial discrimination by prosecutors in jury selection. So let's give it up for our dear friend, Steve Bright.
Thank you, Caroline. I am so happy to know that I'm popular somewhere. I travel to places in this country where people won't drink out of the same Coke machine with me. But before I make a few comments here about unpopular cases and causes, I just want to thank Caroline. I want to also commend you and all the staff at ACS for what a tremendous convention you've had over these last few days. And certainly this last panel, like so many others, has been so stimulating and challenging and good. I hope that someday we reach the element of, or back to some kind of political maturity where we recognize the great service that a lawyer like John Adams provided when he represented people, the British soldiers, in the Boston Massacre, and that we realize that that is lawyer at their highest calling, and that doesn't disqualify them, but if anything, is why they should be in a government position or on the Supreme Court or whatever it may be. But I speak to this topic from some luxury because unlike my friend Debo and Dawn and others, there was never a moment in history when I was even lightly considered for any position in any government anywhere. I don't think. But I have, in 40 years, I don't think represented any client who was not unpopular. So I want to just talk a little bit about the value of doing that and why it's even more important today than it has been at other times in our history. In the last 30 years, in the last 30 years, some lawyers represented two very unpopular men in North Carolina, Henry McCollum and his half-brother, Leon Brown. They were unpopular because they were convicted and sentenced to death for a horrible crime, the murder of an 11-year-old child, sexual abuse, rape. They were intellectually disabled. Their IQs were in the 50s. But last September, they were released from North Carolina's death row because they were completely innocent of those charges. They were released and given $45 and told to do the best they could. We'll never understand what it was like for these two men, these intellectually disabled men, to be on death row for 30 years. We will not know what they thought when they saw other people that they knew there who were marched off to the execution chamber and never came back. We know that Henry would become so upset during an execution that he would be put in solitary confinement to keep him from hurting himself because he became so distraught during an execution. Finally, last Monday, the governor of North Carolina finally got around to signing something that will give them $750,000 for completely ruining their lives. It took him 9 months to get around to it. On April 21st, Willie Manning was released, again innocent, from Mississippi because of flawed forensic science, because lawyers for over 20 years fought for his release. Anthony Ray Hinton in Alabama just back in April, Brian Stevenson's work there. Alfred Brown just June 8th, just a week ago in Texas, after 10 years on death row. In one of the saddest cases, Glenn Ford, who was released on March 11th of 2014 after 30 years on death row at Angola prison. He was sentenced to death in Shreveport, Louisiana for a crime that he didn't commit, the robbery and murder of somebody at a jewelry store. The only connection that Ford had to this case was that he had once done yard work for the victim. And that's all it took for a black man to be accused of a crime against a white victim in Shreveport. And it opens up these issues and problems that we need to really think about in light of Ferguson and Baltimore and so many other places. He was given 2 lawyers to represent him. Neither had ever tried a case before, civil or criminal. One of the lawyers was an oil and gas lawyer. He was the lead counsel, and the other lawyer was a slip and fall lawyer, that very demanding legal specialty of slip and fall. The case was tried in the Cato Parish Courthouse in Shreveport. If you've ever been there, as you go in, there is the largest monument to the Confederacy, and there's one in front of every courthouse that I go to, but this is the biggest one of all. It has Robert E. Lee, it has Stonewall Jackson, it has a couple of lesser Confederate generals on it, it has a soldier up there at the top who I guess is sort of the everyman Confederate soldier, as well as the Confederate flag. And as often happens in capital cases, the prosecutor used his strikes to make sure that no people of color, nobody of Glenn Ford's color, sat on that jury. So virtually defenseless, without lawyers, without money for experts, without anything, this man was tried and sentenced to death. And for 30 years, lawyers worked to show that there was no case against Glenn Ford. And just recently, the prosecutor, Marty Stroud, who tried that case, wrote a letter to the editor of the Shreveport paper apologizing to Glenn Ford and to the community and to the victims and everybody for putting an innocent man on death row. Doctors told him last February, Glenn Ford, that he now has stage 4 cancer. He has only a few more months to live. Shortly after that, the judge denied any compensation for him for the 30 years that destroyed his life. We need to represent unpopular people like this because we need to see the kinds of injustices that got these people where they are. In Ferguson, in Baltimore, and so many places all across this country, we've seen how the police have treated people of color, the unpopular. But what we haven't maybe paid as much attention to is how the courts have treated these people once they've been. There's no question if you're a person of color, you're more likely to be stopped, more likely to be abused during the stop, more likely to be arrested at the end of the stop. But when you get to court, you're more likely to be denied bail. You're more likely to be charged with a more serious crime, a felony instead of a misdemeanor, a capital crime instead of a non-capital crime. And these discretionary decisions that are made all the way through, including the exclusion of people of color from service on juries, the most democratic institution that we have, going on day after day, court after court. The Department of Justice said in its report on Ferguson that the municipal court in Ferguson was nothing but a revenue-generating engine for the community. There's a little court in a city in Georgia that has 455 residents. And last year, the municipal court there collected $1.2 million in fines. These are municipal courts all over the country. These are cash cows. These are not courts of justice. These are courts of profit. And we have to change them into courts of justice. The criminal justice system is a part of our society that's been least affected by the civil rights movement. I go across the South, and many things have changed. In fact, we were talking about, Debo was talking about the change of somebody like my Congressman John Lewis from being the unpopular person who marched in Selma to now being one of the most respected members of Congress. We've seen that change. But I go to the courthouse, and everything is the same. The judge is white, the prosecutors are white, the court-appointed hack lawyers are white. And even in communities, because where I practice, we have communities 35–40% African American, but everybody in the jury box is white. Right now, 2015. And we must be there to see and to understand and to challenge and to bear witness to these things, and it involves representing unpopular people. We need to see what's happening to unpopular people in solitary confinement in Rikers Island, but also in prisons all over this country. If you look in today's New York Times and letters to the editor, Theo Shaw has a letter to the editor. Stand up, Theo. Theo Shaw knows something about this because he was one of the Gen of Six. He was charged in 2007 with so many crimes that he would have spent the rest of his life in Angola prison if he had been convicted of them, if some lawyers hadn't taken on that unpopular cause, that racially charged prosecution. Now I'm happy to say he's going to go to law school on a full scholarship. And sitting beside him is my friend Jared Adams. Jared, I want you to stand up. This young man spent 10 years in prison, including maximum security, supermax, in fact, for a crime he didn't commit. He was exonerated when a unanimous panel of the Seventh Circuit held that he had been wrongfully convicted, and he was released. And he went to law school and graduated from Loyola in Chicago, and next year he's going to be doing a fellowship for a judge on the Seventh Circuit Court, the court that set him free. He's going to be doing that fellowship with Judge Ann Williams, and if you want to help, you can actually go to the web and look for GoFundMe campaign. I thought I had the website down here, but I don't. But at any rate, and you can contribute to that fellowship. It's going to help Judge Williams, but every judge of the Seventh Circuit to have somebody who's been where he's been there at that courthouse. And we need that for not only be somebody who's done the fellowship, but somebody who are in all the other positions there. These are two young men that would have been thrown on the trash heap of prison if only some lawyers hadn't been there for them. And that's why we have to be there in so many other cases. Winnie Davis talked about Earl Warren, but I think so much about Thurgood Marshall, because if you've read Gilbert King's wonderful book, Devil in the Grove, Thurgood Marshall and the Groveland Boys, about Thurgood Marshall going down and risking his life in the late 1940s to represent young black men facing the death penalty in Groveland, Florida, and traveling all over the South and representing people in one unpopular cause after another, taking the train to Oklahoma City and then the bus to Hugo, Oklahoma to defend a man in a death penalty case, all by himself. It was just a train. There wasn't even a car to get out of town when you need to leave. And Thurgood Marshall took to the Supreme Court life experiences and things that he had seen that no other member of that court had seen. And when the court decided what the right to counsel was in Strickland versus Washington, he was the only dissenter. He was the only one who knew this would not protect the right to counsel, and it hasn't. He was absolutely right. He was the one who said when the court decided Batson versus Kentucky This is not going to work. It's not going to prevent race discrimination in jury selection, and it hasn't. In the case that we just took up to the Supreme Court, we discovered the notes of the prosecutor that said, well, we've got to compare the black jurors in case we have to take a black. And then another note that said, if we have to take a black, we'll take Ms. Garrett. But they didn't even take Ms. Garrett. And then they argued to the jury in closing argument, send Tim Foster to death row so that people in the projects don't do things like this. 95% of the people in the projects in Rome, Georgia, like Tim Foster, are black. In North Carolina, the prosecutors had a statewide meeting of prosecutors. This is not some rogue prosecutor's office. A statewide meeting in North Carolina where they distributed a handout called Articulating Juror Negatives, where they told prosecutors how to give race-neutral reasons for striking black people from the jury. Under Batson, once there are strikes of people of color, a cognizable group, and objections made, then the judge calls upon the prosecutor to give the reasons. And it's one of those times in court where everybody knows how corrupt and lawless it is. The judge knows, the prosecutor knows, the defense lawyers know, the people in the audience, if they can hear, know. They know that when he says those reasons, those are lies. The reason those people were struck was because they're black. The prosecutor knows that. The judge knows that. He used to strike all the blacks when he was a prosecutor. And yet we go through this farcical procedure over and over again. And here, the prosecutors have the race-neutral reasons before they've even seen the jurors. In Philadelphia, the chief of the trials felony division there told people after Batson comes down, you're still going to strike the blacks, but when you have those blacks, write down lots of things because you've got to give reasons for striking them. Now that we're not going to let everybody participate in the juries, but we're going to find a way to get around this decision. We've represented the unpopular in death penalty cases. That's what I've done mostly in my life, but also in other people accused of crimes, people on the sex offender registry. I thought representing mass murderers and serial killers were pretty unpopular people, but I didn't know what unpopular was until we represented everyone on the sex offender registry. But I found that when we started looking there, like everywhere else we look in our work, we found injustice. We found people whose lives were ruined. Our lead plaintiff, Wendy Whitaker, who was not able to live where she wanted to live, not able to work where she wanted to work, not able to get a job, all because when she was in high school in science class, I remember this when I was in high school, they decided to show a science film, so they put down the shades and made it a little darker, and they showed this film. Must not have been very interesting because she and this other young man engaged in oral sex while it was going on. Must have been a fairly boring movie, but you kind of wonder why they would have been prosecuted. She was white, he was black. It's no more complicated than that. They both did probation and they got off, but they were on the sex offender registry for the rest of their lives until we got them off for the lawsuit. I've seen all manner of injustices, debtors' prisons, people denied bail and losing their lives or having their lives destroyed even though they were never convicted of anything. The charges were later dismissed. And in these kind of times, with these people, 2 million people more in jail, with these black communities, lives, people, families being destroyed, this is not the time, you law students say, this is not the time to play it safe, so we hope we might someday get a judgeship. This is the time to get down in the trenches and help people that need to be helped. I teach in law school, and I see the terrible, terrible result of risk avoidance. So many people are there because of risk avoidance. So many people can't decide what to do because of risk avoidance. I'm telling you right now, you do not want to die and have your epitaph being that you kept your options open. There are 80 condemned people, some of them are no longer in life, who had no review by the federal courts of their death penalty cases because their lawyers missed the statute of limitations. How much more fundamental can it be? And what kind of legal system lets lawyers practice who can't meet the statute of limitations? When our case got granted certiorari in the Supreme Court, a lot of people said they'd like to write amicus briefs. I said, you know, we don't really need amicus briefs as much as there are people that don't have lawyers. In Alabama, and Texas, and Georgia, and Florida, they need lawyers, and could you help out? I want to say, and unfortunately, we all want to be at the Supreme Court, and we ought to be making policy, and all, but we need to be. If we really want to understand what's going on, we need to be in the municipal courts. We need to be in the trial courts. We need to see how justice is meted out in Blackshear, Georgia, and Tupelo, Mississippi, and Talladega, Alabama, and all those places. Because otherwise, I see so much that I read in the academic literature has no relation, as best I can tell, to reality. Not my reality, not the reality that I see. Certainly no appreciation of the role that race plays with regard to everything in this criminal courts that I'm in. And so it's important not to just be a technocrat, but to be somebody who has a feel, a life and blood sense of what's going on, of the real injustices in this case. And I'm going to take a slightly alternative view on the thing of space and clients. My clients are quite unpopular. When I met Jimmy Horton, he was on death row for having killed the district attorney in Macon, Georgia. He was very unpopular. But Dr. Brazelton said, you know, that every child deserves one adult who will love them unconditionally. Most of my clients, or a lot of my clients, have never had that. But when I become their lawyer, they have that. And two of my clients recently, Jimmy won about 3 years ago, and Tony Amadeo more recently, both of whose cases we got reversed because of race discrimination and jury selection. Both been released now from death row. Both found to be so beyond redemption they should be eliminated from the human community. I saw Tony Amadeo graduate summa cum laude from Mercer University. Jimmy Horton and I check in every month. He and I and his wife Addie go out and have barbecue every so often. I wouldn't mind having these people in my home. I'd welcome them into my home any time, and I would have had them in my home when they were released. It's the realization and the reminder all the time that people are much worse, much better than the worst thing they ever did in their life. What? This is human beings, humanity of people. Some people don't believe in redemption, but you know, a fellow back home was asked if he believed in infant baptism. He said, I've seen it done. I can tell you with regard to redemption, I've seen it done. And it's been a great privilege in my life to be a part of those people's lives. And when I'm in court and when I have a jury, every time that judge or that prosecutor starts talking about death qualifying, or there are people here who can impose the death penalty, I'm going to put my arm around that client because I want them to know that this is somebody I care about. And if that prosecutor is going to get death penalty, he's going to come through me. And if they condemn him, they're going to condemn him. I want them to know that there's somebody who thinks that this is a person who's worth something. And by being close and by showing my love and support, that I can show that this is somebody, and this life is not so beyond redemption that we throw this person away. And so, in addition to the challenges that Attorney General Holder outlined about voting rights, that we've talked about with obtaining fair and independent courts despite judicial elections and despite all the money, in regard to the things that Wendy Davis talked about here yesterday with regard to reproductive freedom and all the other challenges that we face and that we've talked about and that are immense. We are challenged to obtain justice in a criminal system that throughout history has been unfair, from slavery to convict leasing to Jim Crow to mass incarceration, and has destroyed lives, families, and communities. And we have to do, however, what we have to do, and it starts with providing people with representation, to turn around, to move from hatred to reconciliation and from vengeance to understanding. We can't be discouraged by the enormity of it. As Stephen Vincent Benet said in his little wonderful epic poem about the Underground Railroad called John Brown's Body, he said, they did not know the length of the journey or the number of blows that would fall upon them as they worked on the Underground Railroad to get people to safe passage. But they knew they were on that journey. A little bit later in there, he says, we may fail and fail, but deep against the failure, something wars, something strikes a match, something gets up from Sangamon County ground, armed with a bitten and blunted axe, and after 50,000 wasted strokes, brings the mighty hemlock crashing to the ground. Thank you very much.